Okay, Assalamualaikum warahmatullahi wabarakatuh. In this meet, I will tell you about power of attorney according to civil law. First, definition of power of attorney. The general definition of attorney is a letter that contains the transfer of authority from the one party to another for one reason or another that makes the power of attorney unable to do it himself. And according to Article 17 and 91 and 92 of the Civil Codes, the granting of the power of attorney is agreement with a giver of power to another person who accepts for and of behalf of the person who organizes such an affair. Next, features. The power of attorney must use formal language. In addition, sentence must also be prepared in easy to understand language. Even though the language is quite standard, the letter must also contain the statement of the transfer of power or authority from oneself to another party who is appointed to the certain things. And the power of attorney must be complained and type briefly and consistently according to its function. In accordance with its understanding, the function and benefit of a power of attorney is as evidence or statement from the power of attorney that the party receiving the power of attorney does the things described on the contents of the power of attorney. Next type of the power of attorney. If we look at the contents, power of attorney is divided into two types, namely namely general power of attorney and special power of attorney. First, general of attorney. A general power of attorney is power of attorney from one party to another who trusted to take care of the several activities involving the interests of the party giving the power of attorney. Second, special power of attorney. A special power of attorney is a power of attorney given by one party to another whose contents are specifically stated from what legal action the power of attorney is for. Example of the power of attorney. 1. Power of attorney for sales. Power of attorney for to sell a land. Power of attorney to take care of the inheritance. And power of attorney for the debt collection. Next is a nature of authorization. According to Article 17 and 91, the granting of the power of attorney is an agreement of a person as the giver of the power of attorney with another person as the recipient of the power of attorney, in the order of perform an act to be able to on behalf of the giver of the power of attorney. The granting of the power of attorney is consensual. That is, it is made based on the agreement and binding power of the power of attorney. Is only limited to the authority granted by the power of attorneys as well as in terms of the responsibilities of the parties in granting the power of attorney. Next, expiration of power of attorney. According in Article 18 and 13 of the Civil Codes, it's allows the termination of a power agreement, unilaterally or unilaterally. This provision is diametrically opposed to Article 13 and 38 of the Civil Codes paragraph 2, which states that the agreement cannot be withdrawn or cancelled unilaterally but must be based on the agreement of both parties. Things that can end, things that can end the granting of power according to articles of the Civil Codes are: first, the power of attorney withdraws unilaterally. The provision of withdrawal of power by the attorney are further regulated in Article 18 and 14 of the Civil Codes and so on. With this unilateral revocation, it is better if this is done openly by notifying the party who is recipients of the power of attorney. Second, one of parties is died. Articles 18 and 13 of the Civil Codes also confirms that with the death of one of the parties in the power of attorney, automatically the grant of power is ended by the law. The legal relationship of the power of attorney agreement will no longer continue either to the heirs, if this relationship is to be continued by the heirs. A new power of attorney must be made at least there is written confirmation from the heir containing a statement that the heir continues to grant the entitled power of attorney. Third, the power of attorney realizes the power of attorney. From the article of the Civil Codes, the power of attorney is unilaterally gives the right to release the power he has received on condition that one first must, must notify the will of the release to the power of attorney. Second, the release must not be done in inopportune in at an opportune time. This measure is based on objective statement of whether the release can cause harm to the authorizer or not. Next, an absolute power of attorney can be agreed. To avoid uncurrent uncertainty, the power of attorney is related to the right of the power of attorney to be able to revoke unilaterally on one side and the right of sorry, power of attorney to unilaterally release on the other hand. This agreement is called absolute of power of attorney, which contain the following clause: is the power of attorney can revoke the power given to the power of attorney. Second, the death of the power of attorney does not terminate the to, power of attorney agreement. Conclusion: according to article of the Civil Code, the granting of power of attorney is agreement that contains the granting of power to another person who accepts it to carry out something on behalf of the power of attorney. Thus, the power of attorney is tool that now makes it easier for someone to carry out business in the legal field, to make clear interest through the second person who help him with the terms that have been mutually agreed upon. And from what I found, I include that this power attorney has many use. This power of attorney must also use standard, polite and appropriate language. And this power of attorney must also include identification both from the recipient of the power of attorney and giver of power. Thank you very much for your attention. Maybe this all for me. Sorry for my mistake. Wassalamualaikum warahmatullahi wabarakatuh.